And with that, Jean, the floor is yours.
Thank you, Rebecca. Welcome, everybody, to the first Northeast Benefit Services webinar. Today's technology keeps our valued clients up to date with the most pressing issues in the employer-sponsored arena. Excuse me for my raspy voice today. Today we will address conflict of interest regulations which we have seen coming for years. It is ready to be released, I believe, at the end of this month into the world of employer-sponsored plans. This proposed regulation will change the very essence of your relationship with everyone, even us, who provide retirement plan advice to you and your participants. This webinar will also give me the opportunity to introduce Larry Kavanaugh. Larry and I have been partners for 4 years. The reason for the merger was knowing that the Department of Labor was going to continue to place additional regulations on fiduciaries and plan sponsors. Without further ado, I'm going to pass this off to Larry for the presentation. Thank you.
Well, thank you, Jean. And I'm going to have a little background that I'm going to report on how we got to this point that we're at. I'm going to go through some of the recent regulations that maybe will help you connect the dots a little bit, that things that have gone on over the past few years that you've said, oh, now I understand why that's like that, why my statements changed, why all my notices went through the roof. I used to give out 1 notice a year, now I'm up to 6 or 7. It's crazy. And then talk about how that leads into what is now known as, started out as the definition of a fiduciary, who is a fiduciary under ERISA, and then has morphed into what is now known as the conflict of interest rule, and then finish up by kind of setting the picture stage for where we go from here and what do we do and how do we manage all this going forward. In the long run, I think this is a good thing, but it's not an easy thing. And so I prepared some opening remarks. The title of the presentation is the conflict of interest rules and what it means to you as the plan sponsor. And just add a couple opening remarks, and then I'll go into the content itself. This is not legislation. It's regulation. Congress, when it passed ERISA, Employee Retirement Income Security Act in 1974, authorized the law to be administered by the Department of Labor. So this will not be voted on in Congress. Congress would have the option of adopting legislation to stop or modify this regulation, and I think at the end of or near the end of the presentation, there is such a move afoot. I don't think it's going anywhere, but I think it is going to give some guidance to, I guess it's Congress's way of officially talking to the Department of Labor. And they're listening, and they've listened to all the commentators on this. I'll explain a lot about that as we go on. The proposed regulation makes substantial changes to the current regulatory definition of investment advice under ERISA Section 321. Under the proposed rule, a service provider who makes recommendations about investment management is almost certainly a fiduciary. This is not limited to investment advice, but also includes advice about taking a distribution and making sure a participant knows what their choices and options are. It even covers advice of recommending another service provider, particularly if that service provider is going to pay you for making that recommendation. That very function under this new regulation will be a fiduciary function. And then the final remark is that every one of these regulations, bills, laws, et cetera, have to have what's called a regulatory impact analysis. And the one that accompanied this proposed regulation argues that the current definition of a fiduciary, created in 1975, is too narrow a definition for 40 years later. Today, it's commonplace for individuals to direct their own account, something that was unheard of in 1975 when all defined benefits and most defined contribution plans were trustee-directed. So I'll take a second to just make that distinction. A trustee-directed plan would be a pooled plan where all the money is in one account or one fund. It may be a bunch of different investment accounts, but it's one fund, and everybody's share alike. So if that fund returned 10% in a year, everybody got 10%. Participant-directed is just what it says. The plan sponsor creates a menu of investments, and employees can choose among that menu of investments and direct their own account. And I'll touch a little bit about some of the things that pertain to ERISA Section 404C, although that's not the topic of this thing. The topic of this thing is this proposed regulation coming out on not you, plan sponsor, not participants, your employees, but on people like us, on people that are service providers to your plan. And this is going to change the way they have to do business with you. So a little bit of background. ERISA Section 408B2 was effective July 1 of 2012, and that was a requirement, and you should have, and it's your duty and responsibility to know that you have, in fact, received from every service provider, including us, a fee disclosure document. That rule was effective July 1, 2012. It was to be delivered to you by July 1, 2012, and thereafter, any time and every time that a change in that fee were to occur. So if we had a price increase here at Northeast Benefit Services and those fees came out of the plan participant account, we would have to send you out a new fee disclosure notice under ERISA Section 408B2. The other requirement that was in ERISA 408B2 was that we tell you exactly what services we provide, we tell you exactly what fees we charge, and we tell you if we are or are not a fiduciary. In that section, that part of ERISA 408B2 gave rise to what is the definition of a fiduciary. And this goes back well into my recollection was this was ready to go into place 8 years ago at the end of the Bush administration, and it was delayed. I forget why. Things get delayed in Washington all the time, but it was looked at, re-released again in 2010, and now is finally in a position where it's going to be, this has been worked on for 15 years. So after the plan sponsor received every service provider's fee disclosure notice, it was their responsibility to then digest those notices and put them into a participant level fee disclosure, and they had to do that in 60 days between July 1 and August 30th of 2012. In practicality, what has happened is the big main controller of your plan assets, the custodian, or more practically the record keeper, the person who's doing that daily valuation, they prepared that 404A5 notice. Our firm, for example, could amend it and add our fees on as an attachment, or go online and then put our fees into their system so that that could be reported. So you didn't prepare that notice. More than likely, your service provider, whoever that record keeper is, did it, and we helped them with that and notified you to get that thing out. That disclosure, 404A5 participant fee disclosure, is an annual notice, and also the fees associated with it must be reported every quarter on the participant statements, and that's why you noticed a few years ago your participant statement might have went from 2 or 3 pages to 10 or 12 pages. And every fund and every expense ratio and all the requirements of ERISA 404A5 were required to be reported on that quarterly statement. And then an annual summary statement that gets reported every year as well. The third item, and this is where we're at today, and I've talked about this under the top item, 408B2, are you not a fiduciary? And everyone says, I'm not a fiduciary, I'm not a fiduciary. No one wants to be a fiduciary for reasons I'll get into in a minute. But the definition of ERISA 321, as a result of 408B2, were proposed to be changed. And originally the proposal was in 2010, and the reaction to it was pretty resoundingly, we can't do this. So it was put back on the table and finally re-released in its proposed regulation form April 20th of this past year. So that's where we are right now, and that's where the rest of this is going to go. The definition of fiduciary under 321 and how it's going to more than likely make the people that are dealing with your company and your plan fiduciaries under ERISA. So a little more background before we get into that. ERISA is a funny law. I'm not a lawyer, so I don't know if other laws are written this way, but Section 406 of ERISA are the prohibited transaction rules. So pay attention to this because you're going to be scratching your head for a minute when I tell you that 406(21)(c) prohibits the furnishing of goods or services between the plan and a party in interest. Okay, who's a party in interest? Well, anyone engaging in a transaction with the plan. Now, I'm a fairly smart guy. I look at that and say, well, that means you can't do business with the people you do business with. And yes, that's exactly what it means. That's what ERISA says. It is a prohibited transaction for a plan to do anything. So there's another section of ERISA, Section 408, also known as the prohibited transaction exemption rules. And generally speaking, 408B2 allows those transactions necessary to manage the plan and its assets for the exclusive, very important word, exclusive benefit of the plan, the participants, and their beneficiaries. So if it's required that a plan engage in a transaction, invest money or contract services like record keeping or a participant website or something like that, if that's necessary, then the plan is allowed under prohibited transaction section of ERISA to engage in that activity. Another piece of background before we go too far, because this is important to understand this as we move along in this thing. Under ERISA, there are named fiduciaries and unnamed fiduciaries. A plan must name three fiduciaries. The plan sponsor. Typically, it's the corporation that employs the people that the plan benefits. So ABC Corporation, the sponsor of our plan is Northeast Benefit Services, Inc. The plan administrator under ERISA must be named in the plan, and that administrator, again, can be the corporation. The plan trustee gets a little bit different. Most corporations aren't filed as trust companies, so they can't be only an individual or a corporate trustee can be the trustee of a plan. So typically a small business owner, Gene and I, for example, will be named trustee as our plan. I'm okay with that. Or you go out and find a corporate trustee, a bank, a trust company that would step in place and do that. And there are two important points on this, two types of those trustees, a discretionary trustee that controls the assets and invests the money, and a directed, or a better word might be passive trustee that doesn't do anything that the plan sponsor doesn't tell them to do. And that scenario is common because then it takes that individual. Say if Gene or I didn't want to be the trustee of our plan because of the personal liability, we'd go out and find a trust company to do it. But the plan sponsor would be the person directing that trustee, so it falls back on the plan sponsor and better the corporation than the individual for a lot of folks. So we see that arrangement made from time to time. But this is an important thing to understand going forward with this presentation, is that other parties become unnamed fiduciaries pursuant to their duties and authorities. So ERISA has two provisions that cover who is an unnamed fiduciary. ERISA Section 338 says anyone with discretion over the assets of the plan is a fiduciary. The board of directors and the corporate officers are fiduciaries to the plan. They have discretion over those, where that money gets invested, who their service providers are, all the compliance and rules, approving benefits, approving loans. Those are discretionary actions. You're a fiduciary by default. Plan committee members could be fiduciaries if they have authority, if they have discretion. So if I have an investment committee, which I meet with twice a year or so and review the investments, if that committee can say, Larry, we're directing you to change the ABC fund into the XYZ fund, at their discretion, they're fiduciaries. If their job is to recommend to the board of directors, we've reviewed this, we've met with our advisors, and we're recommending that the plan sponsor, the corporation, or its officers direct that fund to be changed, then they're not fiduciaries. Those with signing authority can be fiduciaries if they're the one creating the discretion as to whether a hardship, for example, is approved or a quadro is approved. If that person who signs off on that, it's their discretion that it's approved, then they're a fiduciary. Registered investment advisors under the Investment Advisors Act of 1940 are always fiduciaries under that rule, under the 1940 Act. The rules and procedures that they follow, and I see a lot of investment advisors, very good investment advisors, following their 40 Act very well, but don't understand their duties and responsibilities under ERISA. This regulation is going to change what they do an awful lot, for the better, and it'll all be good. Broker-dealers with trading authority. Broker-dealers will swear up and down, I'm not a fiduciary, I'm not a fiduciary, I'm not a fiduciary. If you don't believe me, read your 408B2 notice from them, because I'll guarantee you that's what it says. However, if I'm a participant in the plan and I grant trading authority to my broker in my brokerage account, he's a fiduciary. Doesn't know he's a fiduciary, but he is because he has discretion. That's 338 of ERISA. Section 321, which is where I'm going forward, covers those rendering advice for a fee to the plan sponsor, the trustees of the plan, if they're different, and the participants in the plan. That's the focus of where the definition of fiduciary is going to change under this regulation. So ERISA, and this one's a little, if you're not focused on this, give me your attention for a minute. This is maybe the second or third most complicated slide I'm doing here, but ERISA 321 currently has a 5-part test, and I'm trying to take you through the changes. The yellow part on this page, if you have a color thing, I'm sure you do, is the changes that are coming to this. And the next screen will summarize that for you. But to be considered a fiduciary today, one must be involved in providing information or recommendations for a fee, for compensation, as to the advisability of investing in securities or other property. That's not only not going to change, it's going to be expanded, and I'll get into this a little bit, and referred to now as covered advice. If I'm giving you advice, essentially that advice will be covered advice by definition under this new set of rules. That the advice be on a regular basis is completely deleted, a one-time occurrence. That I might have met you at a cocktail party and said something to you, well, I'm not getting paid, but if I were paid to do that, that's advice. Pursuant to a mutual, the word mutual is deleted. A understanding, well, it won't be an understanding between the parties. It's a unilateral now understanding. If I think what you gave me was advice, it's advice. If I'm one of those three fiduciaries, you said something to me and I think it's advice, it's advice. With the understanding that the advice is the primary, currently the understanding that advice is the primary basis is completely deleted. I only need to give it consideration and it's advice. It doesn't have to be on a regular or consistent basis or even pursuant to a contract. That is individualized as to the needs of the plan or its participants and their beneficiaries. I don't know what is individualized, but I will comment that I think what they're referring to, for example, is a newsletter. Let's say our firm sends out a newsletter every year and puts in there somehow we think this asset class isn't going to perform. But we send everybody a broad-based release. Today's seminar, right? It's not individualized as to any particular attendee's needs, so it's a general statement excluded. But that comment to that will be expanded under what will be known going forward as an investment advice fiduciary. Will be the name of the person, the characterization, I guess, of the person who is delivering the covered advice. So, stripping out the yellow stuff from the preceding page, it's now coming down to the proposed regulation on the definition of a fiduciary is anyone providing information as to the advisability of investing in securities or other property, pursuant to an understanding by the recipient that it's advice that is individualized to the needs of the plan. You have now met the definition of fiduciary under ERISA Section 321, and that applies to advice I might give to a plan trustee, applies to advice I might give to a plan participant, or the beneficiary, or someone who comes to us with a rollover opportunity that wants to do that. All of that, if I do all of those three things, and it's pretty broad, then I've met the definition of a fiduciary under ERISA Section 321. And so you can imagine all those broker-dealers and banks and insurance companies that heretofore on your 408B2, your plan-level fee disclosure, said we're not a fiduciary, we're not a fiduciary. This changes that. Yes, you are a fiduciary. And how you proceed going forward is the rest of this topic. And interesting stuff. Some new concepts that are being put forth here. Covered advice, I'm going to get into that in the next page. Investment advice fiduciary, that would be the person. I will get to that in the following screen. Then we're going to get into a thing called the best interest contract exemption. And this is where I really want to take a brief overview. It gets really dicey, really detailed stuff that I think for those attending today, just to know that this thing exists is plenty enough. And that part of it is a thing called the impartial conduct standards, plenty enough. And so you can kind of know where you're going with this thing going forward. But covered advice and investment fiduciary, I'm going to get into that in a little bit detail right now. So what is covered advice? Recommendations as the advisability of acquiring, holding, disposing, or exchanging securities or other property, including recommendations to receive a distribution of benefits to a rollover assets from a plan or another IRA. Item 2 is the same thing as item 1, except it now includes the management of a security or other property. And a security, folks, I don't know how many people know this distinction. A security is a share of stock or a bond or a piece of paper that represents something that I don't have in my hands, as opposed to normal real property. I'm here to sell you a building for your pension plan. Well, I'm selling you that building. It's not a security. It's a real building. Or an ounce of gold is not a security. If I give you a piece of paper representing the ownership of that ounce of gold instead of the gold itself, then it's a security. A piece of paper is a security. That's what the definition of that is. Also, covered advice is appraisal, fairness options concerning the value of securities or other property if made in connection with a specific transaction involving the plan. And I'll show you that distinction in a little bit when there's some exceptions to this. Recommendations of a person who will also receive a fee or other compensation for providing any of the three covered advice categories. And they put that in there because there's a lot of folks that you view as trusted advisors that you wouldn't think would be giving you advice on your 401k plan for a fee from someone else, but they are. And this was put in there to specifically make those people say to you, I'm recommending that you use this 401k or that. Well, I have to give you a fiduciary contract. I have to disclose to you that I am a fiduciary, and if I'm getting compensated, I need to tell you that. That's what the regulation's seeking to weed out and expose, not expose, but shine the light of day on that someone's not being impartial here. They're giving you advice they're giving you advice, A, and B, they're doing it to be compensated. So the person who provides the aforementioned covered advice will herefore be known as a investment advice fiduciary. The person who provides the aforementioned covered advice directly to the plan, fiduciary, participant, or their beneficiary, IRA or IRA holder, is a fiduciary advisor when either directly or indirectly, together or through or together with an affiliate. There's a lot of affiliations in our business that plan sponsors don't know about, should know about. If you represent or acknowledge your fiduciary status, you're a fiduciary. You are what you say you are. Or you provide the advice under an agreement, arrangement, or understanding that the advice is individualized to or specifically directed to the advice recipient for consideration in making an investment or management decision with respect to securities or other property. So getting all that, putting all that together, going way back to the screen with the yellow words on it, it was really easy for people to come along and say, I'm not an investment advice fiduciary. I just sold the guy something for his 401k plan and I'm out of here. I don't really care. I don't have any responsibility. Well, now you do. And now you better be prepared to back that up and either proceed as a fiduciary, which is a very high responsibility, or go into what is going to be the exemption, the prohibited transaction exemption to that, which I'll get into in a minute. Before I do that, I'll say there are some statutory carve-outs to this, the counterparty exception. A counterparty is if I'm a real estate agent and I want to sell you a building for your defined benefit plan, it's not that uncommon in big plans. The broker's going to be a fiduciary. But the guy who owns the building, who's selling it to you, he's not. He's the counterparty. If you open up a brokerage window and buy 100 shares of Facebook, whoever owned those shares would not be a fiduciary. They're the counterparty. We don't know who that person is the way we trade securities, and we don't need to. But the broker is. The group annuity carve-out, I'm going to touch back on this in a minute. If you do business with Nationwide, Principal, Hancock, Voya, I don't know who else comes to mind, you probably, not always, but probably have a group annuity, and that's covered by a prohibited transaction exemption granted in 1984, but being modified by this regulation. I'll get to that in a second. Employees of the plan sponsor. If you said to your assistant or your office manager or controller, hey, start shopping a 401k plan, see what's out there, see what's going on in the market, and do a little homework and get back to us. Or review our investment lineup if you can, and give me a report tomorrow. You're excluded from this unless, of course, and I've seen this happen, unless, of course, you fit into another category of an advisor. If you're getting paid or compensated or a finder's fee or something for doing that, then yes, you become a fiduciary. But if you're just getting information together and give it to your employer, you're exempt. Platform providers are exempt. What's a good example of that? A good example of that would be Paychecks or ADP, and the guy comes out to tell you about his record-keeping services. But that's all they do. You're going to hire someone else to pick the investments and manage them and write an investment policy statement and all that stuff. He's not a platform provider. Even the guys, people calling us that I had breakfast this morning with the lady who's the John Hancock wholesaler. She's not going to be a fiduciary. Unless she came and started talking about the investments on the platform, then she would be. But if she just said, hey, John Hancock's a great record keeper, here's our fees, and here's a list of all our funds, she's a statutory carve-out. Financial reports and valuations. Going back to the real estate transaction, because we're all familiar with how they work, if I was the real estate appraiser on that property, and I said it's worth $1 million, I give you a written appraisal, I'm not a fiduciary. That's a statutory carve-out for that. In investment education, and I'll bring that up here because many engagements we go out, and our job is to educate and really motivate employees to save for retirement. The current rules on investment education are a carve-out with some interesting modifications. If in the course of my education I make a recommendation that the J.P. Morgan Mid-Cap Value Fund's your investment, then it's no longer education. I'm over the line. It's advice. So I'm covered. Many commentators have requested the Department of Labor to give you a little more latitude in doing that and be able to mention specific funds and maybe how an investment works or what's in it and that type of thing. So it's kind of interesting. And I believe that will happen. So you're a fiduciary, and a fiduciary has an absolute responsibility to put their client's interests ahead of theirs. They may be paid. There's no problem with paying fiduciaries. They may be paid out of plan assets. But it's got to be pursuant to a written agreement that says what the fiduciary's responsibilities are, and it must be a fixed fee, whether it's a hard dollar fee or a percentage of assets, but it can't be altered, and it certainly can't be altered by that fiduciary. And you must, in that agreement, say that you're a fiduciary. So the best interest contract exemption, a brand new concept, never before seen, it's available as a prohibited transaction exemption when a conflict of interest is present. I'm sure there's more, but conflict of interest would be the denial of fiduciary relationship. Gee, I'd really like to be your fiduciary, but my dealer or my bank or whoever I answer to won't allow me to do it. Okay, I can still be your advisor, but I have to proceed under best interest contract exemption. Variable compensation. This was a big target of the Department of Labor, has been for years. If there's an environment out there where I might get 1/4 of a percent from Fund A, but 0.5% of Fund B, even if I am a fiduciary, I have to proceed under best interest contract exemption and report all of that, which you'll see as we go on. Proprietary products. If I'm a captive agent of an insurance company or an employee of a bank, or my broker dealer says to me, this is the only investment that you can sell for 401k, it's a proprietary product, that I may not be a fiduciary on. I can be a fiduciary, but I must proceed under this concept known as the best interest contract exemption. There's some other oddball things that might cause this, but those are the big three that they were looking for. So what is a best interest contract exemption? It's advice. It's a contract. It's a prohibited transaction exemption available only for advice to plan trustees for participant-directed plans over 100 participants. And many commentators have said, knock that right down to 0, to 1, I guess. You can't have 0 participants. You can have 1. I think that will happen. It's available for advice to trustees of trustee-directed plans. I mentioned that earlier. So a participant-directed plan, if it's just a trustee-directed plan, and I'm going to give some advice, and I'm not a fiduciary, I can do that under the best interest contract exemption to all trustee-directed plans, all IRAs. And participant-level advice, when I'm talking not to the plan sponsor, but to the participant, of plans of all sizes. Well, if you go back up to item 1, and they take that 100 participant limit out, which I think they will do, then it's all advice to anybody that you're talking to. You would be able to do this under the best interest contract exemption. Another further comment, the Department of Labor has always seemed to think there's this bright line test at 100 participants, that somehow employers dealing with companies that employ more than 100 people are much more sophisticated than the company next door that only has 99. I don't think that's true at all in my observation. I've seen plans with a handful of people that are very, very sophisticated, and I've seen plans with 1,000 people, and I scratch my head going, boy, these people just don't get this. So I think that goes away, and I think that'll apply across the board to everyone, and it's clear that enforcement of this contract exemption will be fines and excise taxes on both the advisor and at the firm level. And a lot of firms out there have arranged with their advisors that say, you know what, you're really an independent contractor. If you do something wrong, it's on you. You pay them. We have no responsibility for that. This regulation overrules that and says, yes, you do have responsibility. So you're going to see a lot more governance by the big level firm over what their representatives are doing, because they're exposed to this as well. A best interest contract exemption must be in writing and acknowledge fiduciary status. For example, I am a fiduciary, but my compensation is variable, and I'm going to proceed under the best interest contract exemption. Or, example 2, I can't be a fiduciary because my controlling entity won't allow it, so I'm going to proceed under best interest contract exemption. I must disclose basic information on conflicts of interest and the cost of their advice. I must adopt policies and procedures reasonably designed to minimize the harmful impact of conflicts of interest. And I must commit to adhere to a basic standard of impartial conduct. So I'm going to leave best interest contract exemption for a second and just say that part of that for the next two screens is the impartial contract standard. An impartial contract standard will apply in any best interest contract exemption scenario, any case where it's being used, but some others too. And that's why I'm kind of carving that out to talk about it. And I go a lot deeper on this, folks, but I suspect there's probably a little snoring going on already. I just can't hear it. But a best interest, an impartial conduct standard is applied against the advisor and his firm. The conditions are that the recommendations that you're making must be prudent. That's a long-standing concept in ERISA, the prudent man or prudent person rule. You must avoid unreasonable compensation. Well, who determines that? Well, the plan trustee determines that. Avoid misleading statements about the assets or the fees. You must disclose any material conflicts of interest. Enforcement, this is new, this is interesting. Enforcement would be FINRA arbitration for an individual claim. So if I'm a participant or a plan sponsor and I'm making an individual claim, I already have a FINRA arbitration agreement in my account with my broker-dealer. Other relationships, banks are using, don't think banks, because banks all you have broker-dealers set up, but say, for example, a registered investment advisor who wasn't covered by FINRA, wasn't registered with a broker-dealer. I think that would be AAA, American Arbitration Association. I don't know. No one's really commented on that right now, but that's what I think where that would go. And that's allowable. That you can still go forward with that on an individual claim. But this, for the first time under ERISA, allows for class action suits. So a class action suit for an ERISA claim would be in a federal court because ERISA is a federal law. If a group of IRA holders got together and wanted to sue for breach of contract under impartial contract standard, it'd go to state court for IRA claims. That class action suit's got a lot of these big financial institutions scratching their head going, boy, I don't know what I'm going to proceed here and what I'm going to do, and I'll talk about that at the end. Okay, so the impartial conduct standard is part of the best interest contract exemption. So now I'm going to go back to that topic and wrap that up, and that is going to be the hardest part of this whole thing, guys. So thanks for sticking with me, and I think one of the things you're going to need to know walking away from this is there's a change in the definition of a fiduciary. Almost everybody I'm dealing with is going to be a fiduciary, and or they're going to have to act under this best interest contract exemption. Which must contractually acknowledge your fiduciary standard. It also is enforceable by breach of contract and subject to class action suits. Brokers and their firms will not be prohibited from receiving compensation so long as they permit under advice to commit to policies which forbid sales incentives or awards. So I don't get a trip to Hawaii if I sell a whole bunch of this particular type of 401k plan. Pay different compensation for proprietary products. That's been common practice in the past. If I'm a captive agent of the XYZ life insurance company and I sold their 401k plan, I got more compensation than if I sold another vendor's 401k plan. Demonstrate they have adopted policies to mitigate this conflict of interest. Annually provide all costs in dollar terms for the ensuing 1, 3, and 10-year periods. It must include any and all costs, fees, and expenses associated with it. They must document and retain records of all of the above. I forget how long, probably several years, 6, 7 years. Annually report to annually the customer must receive a report disclosing each and every investment bought, sold, and transactions costs associated therewith. That could be onerous. Provide a website for the account holders of IRAs and the participants in a 401k with that same information on it. And finally, this is a first. I've never seen this before. I don't know where it stands on the final version that's going to happen here shortly. But any entity wishing to use the best interest contract exemption must inform the Department of Labor of their intent. I've never seen anything like that before. So that's kind of an interesting thing. Rebecca, can you just open the line? Were there any questions that came in on, I don't see them, so were there any questions that came in on the...
No questions have come in through my phone. Maybe you want to do we want to take like a minute and open the phone lines?
Yeah, I think that's a good idea. Take a break before I wrap up here and start to wind this thing down. If anyone's still awake out there, I guess. I don't know.
All right, attention everyone on the line. We are going to open up all the phone lines right now, see if you have any questions about any of this really complex stuff that Larry has just gone through. and then we're going to keep going with the presentation before we bring it home. So, just a second, everyone, and we are now all unmuted.
Well, I'll break the ice. This is Randy calling from Buffalo, New York, and it is so complicated, and we have a very small plan. I just feel like I am in a lot of jeopardy as the owner of a small company, offering what should be a benefit for my employees, but I'm doing so at such great risk to myself. I wonder if I should even continue doing it anymore. Just cut them all a check for a couple of grand every year.
Go
Say, go and open up your own IRA.
Randy, I think at the small end, and I know your company and you very well, at the small end, I think that is a very legitimate consideration for doing that. I think at the same time, there's some pressure coming out of Congress and the regulators to force an employer to have a qualified plan, and some states are adopting automatic required qualified plans for their employees. It's a tug, a push and a pull back and forth on these things that from our chair, we've seen over the years some pretty egregious things. I kind of roll my eyes and say, goodness, that's kind of egregious what those guys are doing to that poor plan sponsor. And the Department of Labor is looking to weed that out. So I think that the practical answer, and I'll bring this up at the end again, if you're in a plan sponsor and you have an opportunity to deal with one advisor who says, sure, I'll be a fiduciary, I'll sign a contract, I'll demonstrate all that we'll do for you, and I'll document the process. And someone else who's there going, well, I'm going to proceed under this best interest contract exemption. Me as a small business owner, it's the easiest decision I ever made. Or as someone put up an analogy, Larry, you've got to go in for surgery, and over here we've got Dr. Fiduciary who's done this 1,000 times, and your other choice is Dr. Weiss who did this once before. What do you want to do? How long do I have to think about that decision? Not very long, and proceed with a fiduciary advisor. And I think that's the other big takeaway from what I'd like to see people walk away with today. And there's plenty of good fiduciaries. Frankly, there's plenty of good brokers out there that are doing just a fine job without all this extra regulation. But there's plenty that aren't. And all fiduciaries have to act like this, because they're going to get sued and they're going to lose, and they know it. So they do act like that. So I think it'll be okay. I think one thing it'll do too, Randy, is it'll get the guy with 3 or 4 plans exempted business. You're either going to be a serious fiduciary service advisor to plan sponsors, or you're not going to be in this business.
Mm-hmm. Okay. Yeah.
Well,
I'm just concerned. No.
I understand. And it's a legitimate concern. No question, it's a legitimate concern. Anybody else? I'll go back to wrapping this thing up. If anyone's actually Randy's awake, that's good to know, but I don't know if anybody else is. Oh, that's Jean Smith. I can hear Jean. She's awake. That's good.
Hey, Larry. It's Patricia Slattery in Rochester.
Hi, Patty.
How are you? So let me see if I'm getting this right, because I did have to step away for a minute. So we're going to open the plan up to people that don't have a lot of experience with investing, probably have no retirement or anything set up. So they're obviously going to ask me, well, what do you think? What do you recommend? And we've turned our stuff over to Voya, so I'm kind of out of the loop on being the trustee or anything. So even if I say to them, well, you're 20 years old, you should probably pick a 20, 30, 40 plan or whatever, that's me giving them advice?
Yes, it is.
So I can't say anything to my people?
That's a little different circumstance than what I'm describing here. And remember I said there's a carve-out, a statutory carve-out for you as the plan sponsor who's just doing some regular administrative type of work. You're not covered by this. Plus, you're not being paid for it, which is an important distinction. However, that issue is really a 404C issue, where we've created an environment of a participant-directed plan. And so problems occur when an employer takes over the direction of a participant or advises that participant on how to direct his account. So I'd be very careful on the advice part of that. And you know my relationship with you. You're certainly welcome to refer those people to me in doing that.
Oh, yeah.
But also the default decision for that person who doesn't make a decision. Very important aspect to have in place is that those target date funds, although they're not the only qualified default investment arrangement, QDIA, they're the most common. There's others. That's not the topic of this. I'm maybe going to do one of these things on 404C one day because it's interesting stuff. But the default fund, if it qualifies as a QDIA, qualified default investment, as target date funds do, absolve you of any liability under 404C. So that if you install that decision, and we've done that at your place, that's an important thing to do. I may do another one. It's a very interesting topic. We talk about that stuff all day, but that's a 404C issue, not a fiduciary issue.
Okay, thanks.
Cool. Anybody else? Time's marching along. I'm just going to touch on this because it really doesn't apply to, well, it does apply to employer plans, but the topic is IRAs. Advice about, Rebecca, could you put it back on mute because I hear some. Yeah, we did.
Perfect.
Okay, thank you again. Yep. So IRAs, kind of interesting thing with this. Advice about rollovers create a fiduciary relationship whether you're the plan advisor or not. That's covered by this regulation. If a conflict of interest exists, variable compensation, discretion over the assets, you must proceed under the BIC exemption. If you advise the plan. So Patty, who was just on the line, I happen to be the advisor on that plan. I might be able to manage a rollover situation in that environment. Why? Well, because under ERISA, it is a prohibited transaction for which there is no prohibited transaction exemption. Remember, it's a prohibited transaction, but this one doesn't have an exemption. And that exemption is I cannot control my own compensation under ERISA. So if I'd agree to advise your plan for a quarter of a point or a half a point or $1 million or whatever we agree to, I may not be in a position where I control my own compensation. So if an employer comes to me and says, Larry, you did a great job helping me all these years. I really like what you do. I'm retiring now, and I'm going to take a rollover. Would you manage that for me? Can I? Yeah, sure I can. But under this proposed regulation, I have to do it at whatever the price was for the plan that I advised at maybe millions and millions of dollars. Well, it can't happen. It's not going to be able to be done. And what I'm going to have to do is say to that participant under this regulation, I can't do it. You need to go to someone else, and God knows what that someone else is going to do. He can charge him whatever the heck he wants. So many organizations, many commentators, the organization I belong to, National Association of Plan Advisors, has asked the Department of Labor to consider allowing that advice to continue, allowing that relationship to continue. It must continue at a level fee. Not a variable fee, but not necessarily the same level. So maybe my charge to do his rollover counts 0.75%. Allowed, disclosed, agreed to, signed off on. I think you're going to see that happen. The people in my position, my organizations have said, yeah, we'd like to see that happen. We'll see. Prohibited transaction 8424, you're doing business with Voya. Patty mentioned Voya, John Hancock, whoever that might be. If you have a group annuity, you've already proceeded under prohibited transaction exemption 8424. That will be amended in this regulation so that the impartial conduct standard, also part of prohibited transaction 8424, and a few others that I'm just not going to go into because it's crazy stuff, but that would require an impartial conduct standard agreement to be in place between the plan sponsor and the advisor. I don't think the insurance company has to be a party to it. I would think they don't, but that intermediary would have to have an impartial conduct standard in place. So what's the present status? We're at 1:15, so this is pretty good. We can open up for some more questions. What's the present status as of December 31st, 2015? And I've heard nothing since. There was a public comment period that ended July 21. There were public hearings at 8:15. I listened in on as many of them as I could find that were interesting, and some of them were very, very interesting. Some of them were just nonsense, but that's what you get in public hearings. There was a second public comment period through the end of September, but those comments were limited to statements made during the public hearings. Didn't see one thing or hear about that. But the next thing, and what we're waiting on now, is publication in the Federal Register. When that happens, unless they change the number 8 to something different, it will be effective 8 months after publication in the Federal Register. And I know you guys won't, but the minute that happens, my bells and whistles are all going to go off, and people are going to start analyzing just what that thing says. Next occur anytime, we'll put a little timeline on this to be effective prior to Jan 20. Hey, I was listening to the radio, and I think maybe I got Jan 20. Isn't that inauguration date, or is it like the 17th or 18th or something like that? But whatever that is, right, that's going to be a new president for sure. What party that president will be from remains to be seen. But unless this thing's enforced by that date, whoever the next president could come in, just throw it right in the garbage and say, never mind. I want to appoint a new Secretary of Labor. By the way, the Secretary of Labor, for those of you who are from Buffalo, is from Buffalo, Canisius High School graduate, a very charming man who I met because I happen to know his brother. And but if this thing's going to be in effect by inauguration day of 2017, it needs to be released on or about April 1st because it's an 8-month implementation period. Now, I did say earlier that Congress could do something about this, and they're trying. It's not going to work, but bipartisan legislation has been submitted, which, if passed, which it won't be, if it is, it'll be vetoed, will require an affirmative action by Congress before the final regs are effective. Not going to happen, but it is Congress's way of communicating with the Department of Labor. And what it essentially says, the highlights of it, happen to be completely in sync with what I think they should do and with what the National Association of Retirement Plan Advisors thinks they should do, and allow for plan advisors to advise retirees of their clients subject to mutual consent. So if a person comes to me and says, Larry, I really like the work you did, continue doing it for me in my IRA, it will allow that with some restrictions. You know, I can't go charging whatever I want, but some restrictions I think are reasonable. It's going to make the best interest contract exemption a more reasonable and ascertainable standard. As I said earlier, there's a lot of brokers out there that are good, hardworking people that are giving good, sincere advice to their plan participants. They can't or won't be a fiduciary for whatever reason. Make that BICE thing an ascertainable, understandable. I'd like to see teeth in it, but don't make it so silly that you're just churning out all kinds of paper that nobody reads anyway. So I think that's going to happen. Allow more time for financial institutions to comply. I think what you're going to see there, they're not going to change that schedule I just reviewed because it just take the whole thing right back to home plate. 3 strikes, you got to start all over again. We don't want to do that. But I think what we'll do is say we will allow, this is not unprecedented, a good faith compliance period of a year or 2 for people that are going to, particularly in the BICE, to set up the systems and procedures that you need and the impartial conduct standard. Give me a year to good faith reliance on that. Allow the BICE exemption for plans with less than 100 participants. I think that's automatic. It just makes sense. And then allow fund specifics in an education component to be mentioned, so that I don't have to refer to it as the large cap growth fund. I can say it's the, what's a good large cap growth fund? American Funds Growth Fund. I can name that fund so people can connect the dots. I think you're going to see that type of thing happen. So, conclusions, effective date on January 1, 2017. It's going to cause a lot of financial advisors to exit the business. I don't mean to be pejorative here, and I apologize. I hope it gets a few laughs. We'll never know, but we call them two-plan Tony. You're not going to be able to operate in this environment and have just a small book of business. You're going to want 100 plans. You're going to want 2. Plan sponsors will need an education. You all on the line today, you're getting your first dose of it, and I think that's a good thing. Part of that will be adopt formal investment due diligence process, write an investment policy statement, hire a fiduciary advisor with a contract, and then do what the Department of Labor prescribes that you do. Create a process, follow the process, document it. That's essentially what we do. If someone alleges a breach of fiduciary duty because, well, the market's in the tank today, folks, in the last 4 months it's been in the tank, that's not a breach of your fiduciary duty. You can't control the market. You can't control what that does. But the Department of Labor showed up and said, well, show us how you made the decisions that you made and what you do. And you say, oh, my brother-in-law is the broker on the account. He told me to do it. That's not good. You don't want that environment. Oh, no problem. I have a written investment policy statement. I have minutes from all the meetings that we maintain. We have a process that we evaluate the investments that we choose, the record keepers that we choose, the prices that we pay. We determine that those fees are reasonable, and we've documented everywhere along the way. In fact, here's all the fund changes we've made in the last 3 or 4 years. Department of Labor is going to give you a clean follow the procedure. Your procedure was flawed. You bought bad investments. It's okay. You have a process. You followed it. And we're going to, this might be a good time. What's my next page? We'll talk about this because we got a few minutes. Let's see. Let's do it this way, Rebecca. If there's not a lot of questions, we can go to that new section on the 5500 that we did the last time and show people that the Department of Labor is starting to ask very much more specific questions on the 5500. In the past, it was pretty much, do you have a 401k plan? Check the box. Yes. Okay. Did it pass all the testing? Check the box. Yes. Well, now they're drilling down and saying, how did you do that? How did you pass that? And one interesting one that's going to lead into all this type of stuff that's coming up here for the 2015 year that just closed out was, were there any in-plan, enforced, or in-service distributions made during the plan year? Oh, yeah. Some guy with $100,000 moved all his money to some annuity his brother-in-law sold him. They do not want to see that happen. And you're going to start seeing more and more of that, and it's going to get closer and closer to the topic that I just commented on. So I just want to make 2 more comments, right? And then I'm going to, and then hand it back to Jean and to Rebecca. But do I have a fiduciary advisor, or is the best interest contract exemption acceptable to me as a plan sponsor? Like I said earlier, you got Dr. Fiduciary and Dr. Bice. I'm picking Dr. Fiduciary in a heartbeat. It's the easiest business decision I ever made. And then how can I adopt a formal investment due diligence process and document that process? Well, that's what an fiduciary advisor is going to do. If he doesn't, fire him. Get someone in there that will, but that's the process. That's what we're going to do. So how about we'll take, and this is the new company we've established. I'm going to let Jean comment on that. But Rebecca, hand it back to you. If there's no comments, we can talk about that questions. We'll talk about the 5500, and then Jean has some closing remarks.
If anyone has any questions, again, in the bottom right-hand side of your screen, there's a Q&A box. Feel free to type in any questions, and then we can read them directly to the presenters, to Larry and Jean. I think we are good on questions, Larry.
Okay.
No questions, Rebecca?
Nope, doesn't look like we have any questions coming in.
Okay, can we put up the 5500?
Mm-hmm.
We got a good 6-7 minutes.
Good.
Let's see. So I'm going to take back.
Yeah, right, you are,
Yep.
Rebecca. Do you have to do anything?
I think I got it on my side. Let's go hold a breath here for a minute.
Okay. We're new to this. You got to figure it out. Yep, I think we're doing pretty good.
All right, and then share my screen. Screen. I guess the Department of Labor's website for the 5500, and then specifically we're going to look at the short form that just came out for 2015, and then Larry, you want to talk about the compliance questions, and then we'll jump down to the IRS compliance questions as well, and we make this bigger.
I think, folks, if you take that, you're making that bigger, Rebecca? You can blow that right on your screen if you hit that little plus button up there. And you
How does it look?
There you go. That's better. That part 10, compliance questionnaires. Were there any failure to transmit participant contributions? That's not a new question. That's always been there. If you're not making your 401k contributions on time, please don't do that, because you got to say to the Department of Labor, actually this is filed with the IRS, Department of Labor, that I'm doing that. You don't want to do that. Were there non-exempt transactions between any party in interest? You know, that's an interesting, and I made this comment the last time we did this. Going back to that whole thing, who's a fiduciary? Everybody knows Northeast Benefits is my TPA. What does that mean? Well, it's the third-party administrator. We're very careful to refer to ourselves as a third-party administrator because we're not a fiduciary. The plan administrator is a named fiduciary. We're a third-party administrator. We don't have any discretion over what you do. We just make a recommendation to you. So in the past, TPAs are always focused on discrimination testing. We do these crazy things called cross-tested that is actually a non-discrimination test under 401A something, 26, I think. And we didn't focus on whether transactions between, whether prohibited transaction, non-exempt transactions or prohibited transactions. Everybody just checked that box, no. Well, the Department of Labor is really focusing on that. It's not what TPAs do. It's not what we're geared to do. And that's one of the reasons we created Northeast Retirement Plan Advisors, because Northeast Retirement Plan Advisors is capable of analyzing a transaction like that and telling you, yes, you're engaged in a prohibited transaction. By the way, party and interest and disinterested persons, same thing. One is by the IRS and one's by the Department of Labor, but a transaction between a party and interest. We're the third-party administrator on a business that I have an equity interest in. If I was the advisor on that plan, I'm checking that box, yes, I can't do that. It's a plan transaction between the plan and a party and interest, a shareholder. So one of the other guys in the office handles that account. Okay, good, because there's no prohibited transaction exemption for that. So look down, okay, part 10. Now look down at question H, that would be I. Oh, I'm sorry, Rebecca, skip down now to, that's part 5. I'm sorry, not part 10. Hey, I'm not good on that Roman numeral thing, okay? And they make the Super Bowl like that every year, and it confuses the heck out of me. Part 9 is the new section. And now they're specifically answering, okay, is this a 401k plan? Yes. Oh, really? If it is, tell us how you passed your non-discrimination. Did you take the ADP test, ACP test, or did you have a safe harbor? 16A, a coverage test. How did you pass your coverage test? They never asked this before. They said, hey, did you pass the coverage test? Oh, hang on, we got to tell you how we passed the coverage test. Look at number 19. In-service distributions made during the plan year. The DOL is focused directly on that, and they want to know if in the process of doing that a prohibited transaction occurred. And the bigger that number goes in line 19, the more is it going to pay attention to you. This section going forward, I think is going to expand. Did you receive each and every plan level disclosure notice? Did you read them? Did you determine that your fees are reasonable? Is going to be a question on here. Did you prepare a participant level fee disclosure? Did you deliver it to your participants? Do you have any best interest contract exemption arrangements with your service providers? Yes or no? I think that's where you're going to see 3, 4, 5 years from now, those questions appearing on that 5500. And I know Randy, who asked the question earlier, was going, all right, that's it. I'm done with this nonsense. You know, I think if you have good service providers and people that understand this and can help you answer that stuff, you'll be fine. I think if you use a fiduciary advisor, you'll be fine. I think if you use a TPA like Northeast Benefits, I think you'll be fine. But I think you want all those pieces in place going forward and be prepared for this stuff. It is not going away. This is absolutely positively going to happen. I think the modifications are limited to what I commented on. I'll be curious to see. We'll know very shortly. But how about we try again, Rebecca, because it's just a couple of minutes too. See if there's a question and hand it back to Jean for a closing comment.
All right, I think that's a great idea. Let me grab this. And, okay, attention everyone, one more time. If you have any questions, bottom right-hand side of the screen. And we're going to open up all those phone lines. So everyone is about to be unmuted. And then Larry, I'm going to give the presentation back to you on your screen. So then Jean can do the last couple of things. Okay.
Well, Jean's going to make that closing remark, but I'll have the screen up. Yeah.
Perfect.
Okay.
So everyone is now unmuted, and then Larry, I just sent you back the WebEx information.
I'm just going to make a very, very short closing remark. after doing qualified plans for almost 40 years, this has me baffled. So if it's got us baffled here at Northeast Benefits, that's another reason why Larry and I came and joined forces. We knew this was going to happen. There were a lot of issues that we can't help with because we are not licensed and we can't give advice. So you have in your packet, you've got my email, you've got Larry's email. I want to just let you know that you can send emails to whomever within Northeast and they'll get back to me. And I thank you for your time. I hope it didn't upset your stomach, and have a good rest of the day.
Thank you, Jean. 1 o'clock, right on the button, folks.
Right on the button.
Yeah.
Okay, thanks, guys.
Thanks, everybody.
The webinar is now over.